Welcome to the channel, everybody. Make sure that you hit the like button, and if you haven't already subscribed, we will be starting momentarily. Just a few more minutes. We're just waiting for them to start the feed. Make sure that you share the video so that others can see what is happening as well. My pleasure. Try to keep everybody informed. For those of you that are not watching on a television that are able to, please hit the like button. Just bear with me, guys. These guys are always a couple minutes late.
I call the meeting to order. Mr. Motz, 1 second, please. I would like to wish you welcome to the 28th meeting of the Special Joint Committee on the Declaration of Emergency, established by motion by the House of Commons on March 2nd, 2022, and by the Senate March 3rd, 2022. And this meeting will unfold pursuant to the standing orders. Now, if there are any technical problems, please let us know so we can suspend the meeting for a few minutes. Now, we have our meeting tonight to examine the future work of the committee. All audio tests have been done for our virtual participant. Our clerk has confirmed that we are good and ready to begin. Mr. Motz, I cut you off. I apologize. You now have the floor.
Very much, Chair. Being we have reconvened and nice seeing everyone again for this meeting, there has been significant developments since the last time we met, specifically with the Mosley decision. And so I'm prepared to move the following motion that was duly placed before the committee, that in light of the developments since the committee's most recent meeting, including a federal court ruling,
I apologize. I'm a new member of this committee, and I would wonder whether motions that are distributed and debated are by order of receipt. I believe my motion was sent in first, and as a new member, I have a question for you. That's a good question. Well, my reflex is to give the floor to who asked for it first, and you raised your hand after Mr. Motz. And to my knowledge, we have two motions. We are to study yours and Mr. Motz. Now, I have no preference one or the other. Because Mr. Motz had his hand up, I gave him the floor. No problem. I just wanted clarification as a new member. Mr. Motz? Point of order, Mr. Brook? After? All right.
Chair, and I'll just start that moving of this motion over, that in light of the developments since the committee's most recent meeting, including a federal court ruling, which found that the government's use of the Emergencies Act to have been illegal, and that the special criminal law subsequently created by the Liberal cabinet to have been unconstitutional, to be an unconstitutional breach of Canadians' charter rights, as well as correspondence from the Privy Council office concerning translation of the evidence before the Public Order Emergency Commission. A, in relation to the federal court judgment, the committee invite the following witnesses to appear separately for at least 1 hour each. A, the Honourable David Lametti, the Minister of Justice and Attorney General of Canada at the time. B, the Honourable Arif Virani, the Minister of Justice and Attorney General of Canada. C, the Honourable Marco Mendicino, the Minister of Public Safety at the time. D, the Honourable Chrystia Freeland, the Deputy Prime Minister and Minister of Finance. E, Royal Canadian Mounted Police Superintendent Dennis Benoit. F, representatives of the Canadian Civil Liberties Association. G, representatives of the Canadian Constitutional Foundation. And H, other witnesses whose names are provided to the joint clerks by members of the committee within 10 days. And 2, an order to issue for all legal opinions which the government relied upon in determining that A, the threshold of threats to the security of Canada is defined by Section 2 of the Canadian Security Intelligence Act, required by Section 16 of the Emergencies Act, had been met. B, the thresholds required by paragraphs 3A or B of the Emergencies Act concerning a national emergency had been met. C, the situation could not be effectively dealt with under any other law in Canada, as required by Section 3 of the Emergencies Act. D, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And E, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act, provided that these documents shall be deposited with the joint clerks without redaction and in both official languages within 10 days of the adoption of this order. B, in relation to the translation of commission evidence, the committee invite the following witnesses to appear separately for at least 1 hour each. A, senior officials from the Privy Council office, and B, other witnesses representing parties which placed unilingual submissions before the commission or entities whose unilingual evidence was before the commission, whose names are provided to the joint clerks by members of the committee within 10 days, and 2, members of the committee shall, within 10 days, identify their preliminary lists of unilingual commission evidence or submissions for priority translation to the joint clerks who, in turn, shall relay those requests to the Privy Council office. C, to accommodate the scheduling of witnesses, the committee meet during the weeks of March 4 and 11, 2024, if necessary, and 2, if the number of witnesses proposed under clauses A, 1H, and B1B warrant, the joint chairs shall convene a meeting to discuss prioritizing their respective scheduling. And D, in relation to the committee's draft report, the committee suspend its work on the current draft report. The analysts be directed to prepare a second draft report, incorporating the information and analysis set out in the federal court ruling, along with the evidence received under paragraphs A and B. 3, members of the committee may, after the committee has received evidence under paragraphs A and B, submit draft recommendations and conclusions for the draft report, including those which may have been negated by the committee on May 16th and June 6th, 2023, where reconsideration may be warranted in light of the federal court judgment or the evidence received. And 4, the committee work toward a goal of tabling its final report by June 21, 2024. So, Chair, this is a very comprehensive motion. It covers off a number of things, and I believe very succinctly identifies some of the areas where we want to go, or I think the committee needs to go in preparation for a fulsome study of and conclusion to this particular event of the invocation of the Emergencies Act. Now, if we look at the reason why we're here and in following along with the purpose behind our committee, the Mosley decision is exactly some of the areas where we need to cover off. Was this legal? Did they follow the rules of law? Was it charter compliant? Those are all things that we need to examine as a committee. And just for everyone's reference, the federal court, I think, provided a very succinct review. I particularly was pleased with how well it was presented and provided clarity on not just he made a decision, but he provided the rationale for the decisions. And I think they were very, very sound. And I want to take just a moment to just refresh our memory on what those decisions were. So on January the 23rd, the Honorable Justice Mosley of the Federal Court issued his decision. So 4 groups applied for judicial review of the decision by the Governor General and Council to declare a public order emergency under the Emergencies Act. The February 14th, 2022 proclamation declaring a public order emergency and the enactment of temporary special measures in order to deal with protests in various parts of the country, which included the occupation of the downtown core of Ottawa, and blockades of ports of entry were under review. This was the first time that the Act was invoked since its enactment in 1988. The proclamation, the Emergency Measures Regulations, and the Emergency Economic Measures Order adopted under the Act had a threefold impact. A, they prohibited a range of activities relating to protests in designated areas. B, they required third parties to assist the police in ending the protests. And C, they authorized financial institutions to disclose information on designated persons and entities to federal officials to suspend their accounts. The applicants and parties raised issues which led to the following questions. 1, was the proclamation unreasonable? With respect to the first question, the court considered the decision under the reasonableness standard of review and concluded that the answer was yes. The proclamation was unreasonable and illegal, ultra vires, which is really a term that means to act beyond one's authority or power. While the court recognized the occupation of downtown Ottawa and the blockades of the ports of entry were matters of serious concern, calling for government and police action, the threshold of national emergency required by the Act was not met. Under paragraph 3A of the Act, a national emergency is an urgent and critical situation that exceeds the capacity or authority of the provinces to deal with it, and that cannot be effectively dealt with under any other law in Canada. The proclamation applied the temporary special measures in all of Canada, in all of Canada's provinces and territories, despite the lack of evidence that it was necessary. Apart from the situation in Ottawa, the police were able to enforce the rule of law by applying the criminal code and other legislation. While the conclusion of the proclamation was illegal, it was sufficient to dispose of applications. The court addressed the other issues should it be found to have erred in its finding on the first question. The court considered the threshold for threats to the security of Canada. Section 2C of the Canadian Security Intelligence Services Act defines threats to the security of Canada as activities directed towards or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving a political, religious, or ideological objective. Under Section 17 of the Emergencies Act, the Governor and Council required reasonable grounds to believe that the standards set out in Section 2 of the CSIS Act had been met. The evidence in the record before the court did not support a finding that the impunged activities reached that threshold. The second question that was asked, did the powers created by the regulation and economic order violate sections 2B, C, D, or 7 or 8 of the Canadian Charter of Rights and Freedoms? And if so, could they be saved under Section 1 of the Charter? Now, concerning the Charter, the court found that the regulations infringed the guarantee of freedom of expression under Section 2B, as they were overbroad in their application to persons who wished to protest but were not engaged in activities likely to lead to a breach of the peace. The economic order infringed Section 8 of the Charter by permitting unreasonable search and seizure of the financial information of designated persons and the freezing of their bank and credit card accounts. The infringement of Section 2B and 8 of the Charter were found to not minimally impairing and could not therefore be justified under Section 1 of the Charter. The court found that there was no infringement of the rights to freedom of assembly, and so that particular piece of the charter was not found to be a breach. Now, I think it's important to recognize that while Justice Rouleau had a role to play in his presentation of the evidence, we don't have a lot of the 250,000 documents that he said he saw. We're never going to see all of them, but he relied on 7,000 documents to write his report. And so I think it's important that we, for some of the words that he used in his justification for his decision, Rouleau, to support the government's invocation was the evidence was underwhelming, and that any other person presented with the same evidence could reach a completely different conclusion. So it didn't leave me with a lot of confidence back in the day, and I've spoken that at this committee, that his decision did not leave me confidence. On the other hand, Justice Mosley's decision from a high court in this country has provided to me confirmation that there was an appropriate judicial review of the act and the use of the act, that it was found to be illegal in this circumstance, and that there was a breach of the charter. So it begs a number of questions. Our role as a committee is to do a number of things. One of the things that Mr. Beattie, our very first witness of this committee, told us, he said, we need to ensure that the act is, our role is to look at the act and ensure that it is adjusted to ensure that no other government can present or invoke the Emergencies Act under the exact same circumstances again. And beyond that, we have asked for charter documents, a charter analysis that we never got. It was a trust us, we've done it, never did see it. And the other thing that Justice Rouleau made a comment about, that it was unfortunate the government chose to keep their broader interpretation to themselves. And Mosley speaks about that a number of times in his decision, that we're just supposed to trust them. Well, you know what? The Canadian public has lost trust with this decision. And so the motion has a number of different components to it that speak to the need to have certain people here as witnesses, the need to have documents. Again, this is not a new phenomenon for this committee. We've asked for documents that the government relied upon to make their invocation, and we haven't got them. In fact, it's quite telling that the government has refused at all levels to prevent some of this documents to be released, and I think it's unfortunate. The other issue that is before us and was left over from our meetings in the fall was the issue of translation. I don't know how we're going to solve that completely. I think we need to come to my personal opinion is we need to come to some compromise on how to make that work and make it work fairly for everyone. And I'm certainly open to conversations about what that might look like. But again, the motion as presented deals with the report as well, and where we need to go with the report and the information we need to include in the report now moving forward, and the goal, with the goal to correct it. I think our longest, as I look forward to our calendar, I think the longest task that we're going to have is developing recommendations that are going to address some of the gaps in the current legislation that we might be able to fix. And we can do that, hopefully, a lot of it as a committee. and then have a report done. And if there's dissenting reports, then those, there's time to get those in as well. I certainly, I'm open to debate on this, and I will acquiesce my time to the next speaker, Chair.
Merci, Monsieur.
Thank you, Mr. Motz. On my list, Ms. Romanado, Mr. Brock, and Senator Carignan. Ms. Romanado, the floor is yours. Thank you very much, Chair. I very much appreciate the explanations given by my colleague.
The committee. And so I too want to see if we can find a path forward. And that is why I had brought forward a motion that I think captures the two issues that are at hand, one of which is the importance of documents being translated in both official languages, and the other, obviously, our colleagues have a great interest in terms of the Mosley decision, which is why I put forward the suggestion to have the two ministers who are responsible brought forward to come and testify here before the committee. So in those aspects, I am in support of the way path forward, I think. I was not involved in this committee and the incredible work that you've done and the meetings that you've had. I have read the documentation from all of the meetings that happened prior, and I did read the draft report that you're working on. And I think if the goal is for this committee to do the work that we were mandated to do, based on the legislation that actually created this committee, Canadians are expecting us to submit that final report, and I believe we are there. I don't believe that we need to revisit having all of the same witnesses come back, based on the fact that a court has found with the Mosley decision something that the Conservatives were of course in support of. So I brought forward a compromise in terms of bringing a path forward and opening that conversation on how can we, between now, we have, I think, 12 meetings scheduled between now and June. How can the committee find a path forward in terms of addressing the question of translation and addressing the question of, okay, while outside of the scope of the mandate of this committee with respect to the Mosley decision, how do we get further explanation? And I think that's the will of the opposition to hear from the two ministers who are involved, and that is why I put a good faith motion forward. So I'm hopeful that we can come to some common ground here and move forward in a positive way so that we can issue that final report. Merci.
Merci, Madame Romanado.
Thank you, Ms. Romanado. On my list, Mr. Brock, Mr. Carignan, Ms. Maloney. Go ahead, Mr. Brock. The floor is yours.
No. Monsieur,
End up too on the screen.
pardon me. Oui, c'est le dernier que j'ai.
Yes, you will be the last. And I'm going to ask Mr. Senator Harper.
Thank you, Chair. And welcome to Ms. Romanado, Mr. Maloney. Welcome to our committee. I know you're... Oh, and Senator Smith. Yes, welcome.
Sorry.
Although you're new, it may seem daunting in terms of the length of time we've all been hearing evidence and discussing these issues. These are important issues. So some of the takeaways that I want to highlight first, I certainly will try not to repeat the comments of my colleague, Mr. Motz, but we are also desirous of coming to a conclusion sooner than later. And I believe there is a path forward to do that by the end of this session, sometime in June. But we never anticipated that when this particular committee began its examination of the invocation of the Act and the circumstances surrounding it, while we heard rumors that there might be a charter challenge, we didn't know to what extent that would look like. We didn't know what the results would be. But we certainly had that at the back of our minds moving forward. And I also want to highlight on the issue of witnesses. Back in December of 2022, with a tie vote, and in this particular committee, a tie vote results in a negative passing of a particular motion. And a motion was brought by the Conservative team to extend the study, to call further witnesses that we deemed would provide relevant information. And the vote was 5-5. So by no means did that vote indicate a strong majority preference, in my view, to shut down the possibility of hearing from further witnesses. We lived by that decision, and we then instructed the analysts to prepare a review of the material and provide us with draft reports. We are now in draft version number 3. In that time frame, we had the Rouleau Commission, and I want to highlight that there's, although it's statutorily mandated that a commission launch during the invocation of an act or following the invocation of the Emergencies Act, and although it was presided by a justice, a Superior Court justice, the mandate of Justice Rouleau was not to provide any charter analysis of the legality behind the invocation of the act. That legal mandate did not exist. And I think in his wisdom, Justice Rouleau definitely shied away from making legal pronouncements because he knew ultimately this was a matter that was going to be studied and argued in the federal court. At that point, 2 institutions, as outlined in our particular motion, had launched a charter challenge, that being the Canadian Civil Liberties Association and the Canadian Constitution Foundation. So Justice Rouleau, as my colleague has indicated in his opening remarks and in the report itself, makes it abundantly clear that the evidence was by no means overwhelming to him to conclude that there was a legal justification by the Liberal government in invoking the act with the circumstances that presented itself primarily in downtown Ottawa and secondarily with respect to some of the border crossings in Alberta and here in Ontario at Windsor. He made it clear that reasonable people who had the ability to review all the evidence that he heard could come to a completely different conclusion than he did. And I highlight that phrase, evidence. And this segues to the concern that our Francophone members have on this committee, that the submissions and the evidence heard at the Rouleau Commission was not translated in the other official language, which has compromised the constitutional right that all members have in this House and in the Senate to receive information in both official languages. Now, we are certainly not suggesting, and the motion was drafted in such a way that we don't want every single piece of material or submissions officially translated into the other official language. It would take years to do that, and I think we received a figure in terms of the cost analysis well over $300 million. And at one point, this committee said, well, you know, that sounds like a daunting task, and given the financial crisis that we have in this country and the affordability issues and many families, thousands of families, literally one paycheck away from insolvency, we have to be prudent stewards of the taxpayer money. So that, in my opinion, would not be a proper exercise of our authority. We talked about perhaps just getting translated the index, an index indicating how the arguments were presented so we can identify who said what, and maybe an index of the exhibits, 2,500 potential exhibits. But again, that price tag was $5 or $6 million, another extraordinary expense that cannot be justified under any circumstances. So the motion is drafted as such that we can hear from individuals to perhaps give us the answers that we seek without going through the expense. And I think I can't speak for my colleague and chair, Monsieur Fortin, but I can speak on behalf of Senator Carignan, and he's certainly on the speaking list, and I don't want to take away his submissions, but I think that was a reasonable compromise. So I appreciate, Ms. Romanato, your approach. I think we're not too far off in terms of where we both see a pathway to proceed with, but I think it's incumbent on us as parliamentarians and senators to give value to Canadians. This was an extraordinary time in this country during the pandemic and the response to the pandemic by the convoy and the supporters of the convoy that descended here in Ottawa. But I think it's a reminder to us all that we are a country of law. We are a country of order. And we don't interpret the laws to fit what we believe as a government, a narrative that's not supported and grounded by facts and not supported and grounded by the legislation. The legislation in the Emergencies Act was abundantly clear. It could not be more clearer that the definition of a national emergency is the same definition as defined under the CSIS Act. It did not say anywhere, or as other interpretations may be available, or as other circumstances may be available. The law was black and white. It wasn't gray. And that's what we expect. That's what we expect in this country. We, as drafters of legislation, use our best skills and resources to provide clarity with the law. Sometimes we get it right, sometimes we get it wrong, and courts and appeal courts and ultimately the Supreme Court of Canada will weigh in if we do get it wrong. But in this particular case, as my colleague Mr. Motz has indicated, we heard from Perrin Beatty, who was a cabinet minister, who was primarily the architect of the Emergencies Act. And as we all know, the Emergencies Act was designed to replace the War Measures Act, which has significant flaws in terms of trouncing on the civil liberties of Canadians. And there was a mandate to do better. It was a mandate that we would create the most strongest, the most powerful law available to a national government in times of true national emergencies. Now, through resources that may not be wholly available to this committee, I've certainly been privy to resources from the government itself, that there was even a consideration of the invocation of the Emergencies Act at the outset of the pandemic. Frightening, disturbing on so many levels. Then we had evidence very early on from ministers such as Mendicino and Lametti, the most powerful legislator, lawyer in this country, jokingly opining with Mendicino on day 2 of the convoy, let's bring in the tanks. Appalling. It was a joke, but it was an appalling remark. I have defended, and I will defend with my last breath as a member of the Law Society of Ontario, the Charter of Rights and Freedoms. And while the Charter of Rights and Freedom is drafted in such a way that these are not absolute rights, they are enshrined rights and they are valued rights. The right to freedom of expression, the right to peaceful assembly, the right to be secure against unreasonable search and seizure. All of which ultimately came to a head with this Liberal government when they determined that, notwithstanding that the City of Ottawa Police Service as well as the City of Ottawa municipal government directed the convoy truckers to park on Wellington Street, directed that there be a off-site location for the supply of materials to run back and forth. All of this was planned. It was organized. There was discussion between legal authorities and the truckers. One thing that no witness has ever been able to answer, and I asked this, if I asked it a half a dozen times, I probably asked it 24 times. At what point in time and at what event did this lawful exercise of the freedom of expression and assembly, as directed by legal authorities, become unlawful? No one could answer that. The only thing I could surmise is that it became inconvenient to the government. It was certainly inconvenient to citizens in downtown Ottawa. The smell of diesel, the noise, the commotion. But in Justice Mosley's words, that's not a national emergency. That's what protests are. Protests can be loud. They can be uncomfortable. They can be a nuisance. But it doesn't rise to the high legal threshold of a national emergency. Now, all I ever heard, as well as parliamentarians and Canadians, is that this was required, that lawful legal measures was simply incapable of dealing appropriately with the removal of this blockade. And there's contradictory evidence, and I'm not going to get into that. The evidence is already on the table on that issue. But more importantly, what we heard from the Prime Minister to Marco Mendicino and David Lametti and Minister Freeland and Minister Blair and probably the entire cabinet bench was, this was necessary, this was lawful, and we had legal justification. It was charter compliant. When we asked for evidence of charter compliance, oh, you can't have that. That's protected by cabinet confidentiality. Or you can't have that, Mr. Brock. That's protected by solicitor and client privilege. But the Prime Minister had no problems waiving privilege, had no problems waiving confidentiality with Justice Rouleau, save and except that legal opinion that they received from the Department of Justice, which would have laid out under what legal authority do you have as a Prime Minister and government to invoke that act. They would not share that even to Justice Rouleau. And I remember this exchange because I watched it live and I read the transcript after we heard the in-chief testimony of David Lametti, former Justice Minister, and the cross-examination, as judges often do and are entitled to do. They question the witnesses. And Justice Rouleau did that. And Justice Rouleau, I'm not quoting word for word here, but essentially said, well, you're not going to give us the legal opinion that justified your use of the Invocation Act. Am I to take from that, I'm just simply have to accept your opinion that it provided you with the legal authority? And David Lametti said, yes, take my opinion. He could be right, but he also could be wrong. And I think it's important that we have access to that legal opinion, which is why we set it out in the notice of motion. And I think long term, because ultimately the government has telegraphed, like literally within minutes, telegraphed an intention to appeal Justice Mosley's decision, a very senior justice appointed by a Liberal Prime Minister, I might add, a very senior justice of the federal court. Other significant decisions that we have heard that impact the lives of Canadians, well, we're going to take it under advisement. We're going to examine all the circumstances behind the decision and weigh our options before we consider an appeal or not to appeal. But not this. Literally a jackrabbit response. He got it wrong. We heard that from our new Justice Minister. He committed judicial errors. I'm sure at that point our Justice Minister didn't even read the full decision. It was a very lengthy decision. And I would be surprised if he had the time to read the decision in full before he quickly pronounced all the judicial errors that Justice Mosley made in his decision. But this again was parroted by the Deputy Prime Minister and many other ministers. There are justifiable legal errors that we can appeal. Now, I'm saying this because ultimately, if they hold true to their word and they will appeal this decision, ultimately the appellate court, wherever that may be, the Federal Court of Appeal, maybe ultimately the Supreme Court of Canada, is ultimately going to hear from Department of Justice lawyers as to what the legal advice they gave to justify the invocation of the act. It's eventually going to come out. If it's going to come out eventually in this promised appeal, then let us share this with parliamentarians, let us share this with committee members, let us share this with Canadians, because they have a right to this information, as do we. So, I've gone on long enough. I know other members want to talk, and I don't want to sit here till 9:30, so I'm going to cede my time back to the chair. Thank you very much.
Merci, Monsieur Brock.
Thank you, Mr. Brock. Senator Carignan, you have the floor. Thank you. I think it is wise to recall, especially for the newcomers who were not here, to recall what unfolded, especially September 22nd of 2022. We wanted to hear from witnesses, a number of witnesses, namely the Prime Minister, but certainly a number of witnesses. And the committee, in its wisdom, said that will double the work. If you know, the witness will go before the Rouleau Commission, before House committees, let us resolve that all testimony that is presented before the Rouleau Commission or before the committee come before us, so that we can take that testimony into account. And I recall this because it's important. We know that we cannot examine all of the evidence put before the Rouleau Commission. So the idea is to just listen to some witnesses. We can't examine all of the Rouleau Commission evidence. Why can we not? Well, we asked that it be translated. At one point, we realized it hadn't not even been translated. And when I talk translation, I'm not talking about this as just a francophone. Even the French testimony is not translated into English. So you, as Anglophones, might say, well, I don't understand the French, but there's, French testimony, and I would be, embarrassed. So this problem applies both to Francophones and Anglophones. A good part of the documents, when tabled in English, are not translated in French, and when they're tabled in French, they're not translated into English. So we wrote, and we asked, could you, the Privy Council, please translate the documents? After several months, the PCO said, well, it's complicated, it's lengthy. Instead of telling us right from the start it would be long and complicated, we waited months, and then we wrote a letter from the chairs and say, when are you going to send us the translated documents? PCO took the time. And we learned just before Christmas that it was going to be very difficult task. So we then asked for an index so that we could then pinpoint which testimony wanted translated. We were told it would take a year just to get translated what's in the index, and the cost would be $300 million, and it would take years to translate all the evidence. So what do? The spirit from the outset was to listen to the witnesses, and we cut back on the witnesses, say we're going to take the evidence put before the Rouleau Commission, but that was impossible to then do. And that is why I worked with my colleagues to identify a list of witnesses and of documents, a modus operandi, so that we could at least have the witnesses that we would not have had to bring in if we'd had the evidence put before the Rouleau Commission, but produce that evidence that we wanted, and then be able to come up with a framework with which we were comfortable. Now, at the end of the motion, well, my constitutional rights have been violated. It is absolutely certain that it's going to be a point of privilege for me at the Senate, because we cannot work as a committee without having heard from the witnesses and having had the documents in the two official languages. We need that. And with all due respect for our new colleague, I had a look at your motion, and it does not encompass the issue of translation. It just says we're going to, ask PCO to explain what's unfolded. Well, they've already told us. They can come and tell us why it's going to cost $300 million. But then what do we do? How do we access the evidence? We need to bring in the witnesses, and we need to find a way to identify minimally those documents we deem important that need to be translated, to have them in the two official languages. Otherwise, we cannot do our work. It will be partial, and it will violate our constitutional rights. I believe that the motion we have tabled is a compromise. It allows us a modus operandi. Maybe there's a little bit of fine-tuning, a bit of a cleanup, or maybe a bit more clarity, but we do need this to be able to finish the report and to respect the spirit of the motion of September 22nd of 2022, where we said, we can't hear from all the witnesses. So we must find a way to proceed. It needs to be in the 2 official languages. And we know that in our parliamentary committees, everything needs to be done in the 2 official languages. And as to the Rulo Commission, well, I've already filed a complaint with the official language commissioner regarding the Rulo Commission, and I have another complaint in regard to the Privy Council. And so all with a view to this never, ever happening again in the future. But to do the work we need to do, we need the witnesses and we need the documents in the 2 official languages. And if there's any member here who does not understand French or, can't read in French, needs the translation, I think, it's a big shortcoming. Big shortcoming. Thank you.
Merci, Sénateur Carignan.
Thank you, Senator Carignan. Now the floor is Mr. Maloney.
Thank you, Chair. I'm also a new member to this committee, and I don't have the benefit of having sat through the many meetings or testimonies provided, and you discussed all these other issues. So I'm sometimes think that might be a useful perspective because I'm a fresh set of eyes. Although I'm sure some will disagree with me. Senator, I am one of those people who does not speak French, one of my many regrets in life. So I will need the benefit of translation, and I agree with you, sir, that we must do things and conduct ourselves in a bilingual fashion so that that resource is available to all. So thank you for pointing that out. But look, I'm going to address something Mr. Brock said. I mean, if I look at the Emergencies Act, what this committee is doing, it's meant to be a contemporaneous review of following the invocation of the Emergencies Act, not to review whether or not it was appropriate to invoke it, but to review the exercise of the powers and performance of its duties. And Mr. Motz said in his submissions that, the report needs to address gaps in the legislation. From what I've seen and read and heard, we're in a position to do that now. I mean, Mr. Brock, there's a certain amount of irony in my mind when he welcomes Ms. Romanato and myself and Senator Smith to the committee, combine that with their motion when you're bringing in all of these proposed witnesses under all sections of the motion, because it sort of flies in the face of the contemporaneous notion, because some of these people have retired, some of them people are now ministers, in fact, former members of this committee. If we proceed in the fashion that you are proposing in this motion, I suspect the 3 of us won't be the last new members who join this committee and have to get up to speed on this. Look, we have 2 issues at hand. One of them is the documents and dealing with the bilingual issue and getting them translated. I disagree with the senator's position again, because Ms. Romanato's motion does address that issue. We'll have people from the Privy Council who come in here. That does not foreclose having other witnesses, but it gets us to a place we need to be to understand why they are telling us what they're telling us in terms of costs and time and whatnot. I don't think anybody will agree that it's a good idea to spend all of those years waiting for translated documents. And if I look at this motion, it occurred to me as I was looking at it, subsection, it's B, big B, small 2, it says one of the witnesses they're proposing to call are members of the committee shall within 10 days identify the preliminary lists of unilingual commission evidence or submissions for priority translation to the clerks, who in turn shall relate. So if I read that correctly, what's being proposed is you bring in people who submitted documents in only one language, have those witnesses come here and testify to what end, I'm not quite sure, except that we want to make a decision based on that evidence to then decide which documents we want to translate. that seems a bit like chasing my tail, to be completely candid with you, and doesn't seem to be a productive exercise, because I don't think it'll get us any closer to getting those documents translated than we're at right now. So my suggestion would be that we look closely at Ms. Romanato's motion, deal with the two issues at hand. And the other thing about this motion is, Mr. Brock talked about the Mosley decision and Justice Rouleau. I mean, I suppose I could sit here and pontificate about who was more senior at the bench and whose career was stronger and whose opinion I will put more weight on personally. But I don't think any of you would want to hear it, and it wouldn't be particularly useful or productive. But that's not our job either. We're not a court of appeal. We have a very specific task to do in a very limited time frame, and we're past that time frame. So I would, and the part of their motion suggests that this report that we're going to deal be done by June of 2024. It's not possible, because this appeal will not, it probably won't even be perfected by June of 2024, let alone decision. We're not, otherwise, why don't we just all agree that let's reconvene after these appeals are exhausted, whether it's the Federal Court of Appeal or the Supreme Court of Canada, and then we can review all of the evidence that was put before these. It's an absurd assertion, I realize, but that's sort of where we are. We have a job to do. I would suggest we take the information we have. We have the two witnesses proposed by Ms. Romanato who are going to address some components of the Mosley decision. I don't know that new evidence will be allowed on the appeal, Mr. Brock. I suppose somebody could argue that, but I don't think that's realistic to expect that there's going to be evidence put before an appeal court that wasn't heard at first instance. Well, there was a suggestion that some of the documentation with respect to the justification for the invocation might appear before the court. So they're going to have exactly the same documentary record and appeal that they did at first instance. So that won't offer any new insight. So my view is that we should move quickly, move to Ms. Romanato's motion, and deal with the two issues at hand, recognizing the time constraints we have and the physical constraints we have because of the documents. Thank you, Mr. Chair.
Monsieur,
Mr. Naqvi, you have the floor.
Thank you very much, Chair, and my apologies that I'm attending this meeting virtually given my parental duties. But I am one of the members, along with a few of the members who've been part of this committee from the get-go, and have sat through hours and hours of meetings and these similar conversations and witnesses and hearing their perspective on what happened. As I read the motion that is being tabled by Mr. Motz, I'm inclined to think this is an effort to have this committee act almost as de novo, just because of a decision from a court of first instance only. In my view, this motion is too broad. We have heard from most of these witnesses already that information is available to us to do our job. And just because we have one decision from a trial division level does not gives us enough reason to start all over again. Not to mention, as I'm hearing my colleagues speak, especially from the Conservative side, I'm again reminded that they're attempting to go beyond the scope of the legislation. And again, I remind members of this committee to look at Section 62, Sub 1 of the Emergencies Act that outlines very clearly as to what the scope of this parliamentary review is. And if, by Mr. Brock's assertion, if Justice Rouleau was not required under the Act to look at the issues of constitutionality, then I would suggest to you, if you look at the wording in Section 62, nor are we asked to look at the constitutionality of the matter. We've got the Rulo Commission before us, and we have that extensive report. We obviously have a decision by Federal Court Trial Division as well. I think what we need to focus on, and this is where I suggest that we hear from Ms. Romanado and her motion, that I think it presents a far more credible path in terms of inviting both the Justice Minister and the Minister of Public Safety so that we can hear their perspective as to the Mosley decision, that we hear from the Privy Council to better understand the issues around translation, and collectively come up with a path that will allow us to bring this committee to a conclusion with a report that will serve the best interest of Canadians. I think it's quite obvious that we may have more than one report in this matter, just being part of this committee for 2 years now, almost 2 years, and hearing the views, and that's okay. I think that people are entitled to do so. But let's get to the point where we can share our perspective with Canadians, given the amount of work we've done. But keep going back in circles, starting anew is not going to serve this that purpose, and I think we will be providing a disservice to Canadians. Thank you, Mr. Chair.
Merci, Monsieur Nagvi.
Thank you, Mr. Nakfi. Senator Harder?
I'm going to be relatively brief, even though the cameras are on. We're now almost entering our third year in this committee. It had been my hope for those of you who have joined subsequently that we would report before Rulo finished his report. You realize how naive my wishes were, but I viewed the work of this committee as rather limited. And indeed, you could argue whether or not this committee should have been formed at all, but that's another matter worthy of debate. We are not an ongoing commentary of all of the actions taking place in other streams. Rulo had his mandate. We've now had one trial division judge. We've still got a class action suit. Are we just going to continue to sit to pick out parts of whatever legal processes might be in place to reinforce our biases or our views? I don't think we're going to change views in our discussion, frankly. They haven't changed in 2 years, so I don't think that that's going to come. So I think we really have to figure out, do we want to finish or not? The motion before us, I oppose, because frankly, it's a motion purporting to bring conclusion, but will ensure conclusion never takes place. I would rather see us go forward in the spirit of what Member of Parliament Romado has suggested, to open it up, yes, for some additional witnesses, but we were so close to finishing our report and making our contribution, which isn't the last word by any means. On the issue of translation, I'm not sure I agree with my Senate colleague, as much as I respect him, that it is a constitutional right to have every document of every commission translated. The Privy Council Office has said that the actions of the Rulo in terms of translation was compliant with the Officials Languages Act. That's our obligation to ensure. If there's other legal processes that will define whether or not that is adequate, God bless, go forward. But I think it's a tactical maneuver to prevent us from concluding. We have Rulo's report, 900 pages. Are we really thinking, waiting 4 more years to have more translation will change anybody's mind or even be read? I don't think so. So I would urge colleagues to put aside the processes that we put forward to kind of pretend as though we're wanting to move forward when we're ragging the puck, and get more ambitious about concluding this committee so that before we rise in the summer, we've made our contribution, because I think we adopt this motion, you can guarantee that we'll be meeting until the end of this Parliament.
Merci.
Thank you, Senator Harder. And now, Mr. Green, you have the floor.
Say I've certainly benefited from taking the time to listen to everybody's arguments. As you know, throughout this process, I've been fairly consistent on taking principal positions that I think are consistent with our party, and as a party that supported the invocation of the act on its face value based on public information that was readily available, and while respecting the summary that was put in terms of the context, it seems that we always miss the context that there was an armed action in Coots, one that I think that the average objective person would look at as a threat of terror, given its attempted targeting of police. And as somebody who has a long history of being critical of the police as an institution, in this particular case, I think it's incumbent on us to recognize the seriousness of that moment and what that could have meant across the country. Now, you'll also recall that throughout the 3 years, I've been fairly consistent in supporting demands for documents. I believe that the public has a right to know, to the best and fullest of its abilities, the same information the government side has had privy to that got to the rationale. And I would state, like right here on the record, that I think that through this process, the government has failed to articulate itself in a way that is consistent with the law as it's been explained to us by numerous experts. But I have to recall the frustration that I had prior to the revelation of the scope of untranslated documents, about us getting to a place that I think we were at 39 of 50 recommendations we had already voted on. Like, we were already there. And nowhere in Perrin Beatty's, who I thought was perhaps one of our most learned experts, nowhere did I hear him say it's our mandate to be a book report club for Rouleau or any other judicial proceeding. That was not in the spirit nor in the language of any testimony that I've heard, and I think we've fallen into that trap. I think that the issue of translation is a serious issue, and I commend the senator for taking it through its obvious complaint and appeal processes as it relates to the commissioners and the Privy Council. But I would agree with Senator Harder that there is a translated version of the Rouleau Commission. And I can tell you, that I don't have the resources to sift through tens of thousands of documents. I don't think any of us do. And so at this point, I'm willing to accept translated documents as legislated through our Official Languages Act, and I'm ready to move forward. Now, I also want to honor the spirit of the search for documents and the search for particularly what are the threats to security and what's the threshold. I think that is a material issue that has to be addressed by this committee in order for us to have adequate recommendations that would hopefully modernize this act to contemplate the current social, economic, and political context that we're in that certainly wasn't contemplated back when Perrin and Beatty drafted this piece of legislation. And so what I would put to this committee as a way of trying to find that common ground is I do believe that Ms. Romanato, MP Romanato, don't sell yourself short in your short time here. This is a good motion that you've put forward. I think that there is concessions there in terms of the witnesses. Because, let's be clear, we're offering a revisiting of witnesses in a way that we didn't consider during Rouleau. And if we're going to really open all this back up, then let's hear from the folks who were held captive in the nation's capital here, the residents and all the other people who testified at Rouleau. I don't think that makes sense for Rouleau, and I don't think it makes necessarily sense for this report either. But what does make sense to me, and I would put this to the movers of the motion, is if we break this up section by section, I'll tell you right now in this open session that Section A, subsection 2, which is your demand for documents, I support that. I've always supported that. And I think Canadians do have a right to know what were the legal thresholds the government was using to make this decision. I think that's material to our report, and I think that it would help dovetail. into the work that we've already done, the 39 or so recommendations. I'm prepared to pick up where we left off, and I'm prepared to accept the Mosley decision as an appendix to this, as we did with the Rouleau in its translated version, and I commend MP Romanato and the Liberal side for agreeing to revisit the other folks. I know this, having worked on this for 3 years. Minister Virani is going to be a very learned member as both a participant of this committee and the new minister. And I think that these are the folks that are ultimately accountable under their new ministerial mandates. MP LeBlanc, I think that's great. But what I'm not interested in is kind of opening this back up. And I've expressed that both offline, and I'm going to say it in open public now. And for those that are watching, before you get your fundraising emails, this is not a cover-up. This is a 3-year process that needs to come to an end based on a mandate that we have as a committee without any conspiracies. There's lots of time for folks to get their say in these upcoming appeals and civil proceedings. And I would just ask that we do find that common ground, that we break this motion up. That would allow me to support the demand for documents. And then as it relates to Section B, I think that subsection B and MP Romanato's motions are similar enough that I would be prepared to support MP Romanato's motion should it come to the floor next, after having supported the demand for documents. Those are my only comments that I'm probably going to have today. Thank you.
Merci, Monsieur Green.
Thank you, Mr. Green. I have on my list Mr. Brock, Senator Carignan, Mr. Mott, Ms. Romanado, and Senator Boniface, and I will add my name to the list. So, Mr. Brock, you have the floor. I see Mr. Brock. Do you want to give your turn to Senator Carignan? Yes,
OK. Non, Monsieur Mott a déjà parlé.
No, Mr. Mott has already spoken. The next would be Senator Carignan. If you'd like to come back after him, you can. Senator Carignan, I would like to come back to the motion. MP Romanado's motion. It's like a motion of closure because you want to invite the officials of the Privy Council to talk about what happened to the translation of documents, and we're asking Ministers Virani and LeBlanc to come. But after that meeting, no further witnesses would be heard from, and then the rest of our time as a committee would be devoted to drafting the final report. There's nothing on the testimony heard that was unilingual, or the witnesses that would come to complete that part of the evidence we don't yet have. There's nothing on the production of documents. There's nothing on the translation of those documents. The memorandum to invoke the emergency measures is not translated. Unilingual in English. We cannot be contented with that.
Merci, Sénateur.
Thank you, Senator. Mr. Brock, are you ready to take your turn?
Mr. Mott, il était le prochain sur la liste.
Mr. Motz was next on my list, so you have the floor, Mr. Motz.
Thank you very much. Just a couple of reminders to the committee, some of which obviously you haven't had a chance to review everything. Mr. Maloney, you mentioned some comment about the committee. And I just want to refresh the committee's memory about the Senate law clerk's evidence that he provided to us early on about our mandate and what it is that we're supposed to be doing. Accordingly, the law clerk's evidence was, accordingly, this committee is master of its own affairs, subject to any direction from the House and the Senate. It can determine what information may or may not be relevant and necessary to the task it has been assigned, and it can determine whether a given line of inquiry is or is not within the scope of its mandate. In other words, the committee is within the rights to determine on its own whether any given line of inquiry or piece of information is relevant and necessary to his work. Additionally, the then House Law Clerk opined as follows, that while the mandate of the committee does not explicitly include the circumstances that led to the declaration being used, it will be for the committee to determine whether or not what extent consideration will be given. Now, what's interesting is there was another comment from the Senate Law Clerk said that, indeed, my understanding, among other things, that the role of the committee is precisely to look at whether the exercise of powers that were put in place is consistent with the Charter and other instruments. Additionally, my colleague, Mr. Carrignol, he asked a question of Mr. Dufresne, the senator's interaction with the House Law Clerk, and he said, we still need to review those powers to determine if they were appropriate or not. If the powers were taken on illegally, that may mean that they were exercised inappropriately. That was Mr. Carrignol's question. Mr. Dufresne, at the time, the senator's interaction with the law clerk, House Law Clerk, said, that will definitely be part of how you interpret your mandate. You will be able to ponder those questions, that is, try to determine whether the powers were exercised appropriately, the situation in which the powers were taken on, and whether it has been anticipated. So, I mean, I want to go back to the question of Section 62. 62 says that the exercise of powers and the performance of duties and functions pursuant to the declaration of the Act. I appreciate your comment, Mr. Maloney, in respect to you wondered whether we should even still be sitting after the fact. And, you know, in an ideal world, this wouldn't have had to be invoked. But when it is, the idea of this committee is to sit contemporaneously, as you said, at the same time as the government is trying to navigate this process. And our very purpose is to ensure that the government is following the law, not an interpretation of the law. They are following exactly what the law says. That was what our role would be if this was still going on and we met at the time. Additionally, the performance of duties and the functions. So the Act is very, very clear that it needed to be charter compliant. It needed to fit with the Section 2 of the CSIS Act for national emergency. There had to be a threat throughout all of Canada. And so our role, to me, is quite clear that that's exactly what we're supposed to be doing. We're supposed to be looking at whether or not the government acted lawfully and whether or not they were compliant with the Charter. That's what the mandate of this committee is, in my opinion. The exercise of powers is exactly that. Exactly that. Did the government act within their legislative powers to do what they did? And so I appreciate we might disagree, and that's okay. And I appreciate the comments that have gone on. I too don't want to sit here for years to come, and I think we can get this done, expeditiously. I believe the Canadian public, who we are here to serve, deserves to know what it is that we are doing, why we're doing it, and that obviously there will be more than one version of a report. I'm confident of that. And so I guess the question needs to be asked, how long do we beat our heads against the wall to try and get a report that we can almost all agree to? And when do we say, you know what, this particular report does not align with what I believe the Canadian public deserves, and you present your own. So I think that's just something that I wanted the new committee members to be aware. I think we're going to be having bells here very, very soon, from what I'm hearing. And I do respect Mr. Green and your suggestion that there may be some compromises, as we all said at the very front end. We need to look at what those might be, and if everybody's in agreement while we vote or whatever that looks like, we can maybe suspend for a little while and see how we might be able to come to some compromise from both sides. Sherry,
Merci.
both sides compromise.
Thank you. Thank you, Mr. Brock. Sorry, Mr. Motz. And now, Ms. Romanado.
Merci beaucoup, Monsieur le Président.
Thank you, Chair. I'm going to cede my time to a senator who has not yet had an opportunity to speak. She's on my list. Senator Boniface, the floor is yours.
Thanks for all the comments. I started out thinking that we weren't going to get very far, and I think we are coming to an end. I have as well been here for almost 2 years, and I think that we need to think about the impacts of various decisions that will come. I don't disagree on taking into account what Mr. Mosley has said, or Justice Mosley has said, but I also want to remind you what we have to work with. Justice Mosley's report's 190 pages. Rouleau's report's 2,000 plus pages. And as Senator Carignan has rightly commented on, that there's a number of the briefs that aren't translated. But we as a committee have had 26 meetings so far. This is meeting 27. We've heard from 66 witnesses ourselves. And we've spent multiple meetings drafting a report and recommendations that I would have thought we were getting near the end of. We were certainly beyond the halfway mark, to say the least. And I think that the work we've done around recommendations are actually very good and won't necessarily change. But I think that some of them won't, but we have to look at it through the lens of a new perspective, which is Justice Mosley. I have no problem with that. So I look at it, and I really like the comments of my colleague, Mr. Green, my co-chair. And I asked the question around legal opinions because we've asked for these already and not got them. We will have 2 ministers here, one of them who will be the Attorney General of Canada. We can, in our questions, ask him if he will produce those legal opinions. But my question is this, my point is this, Mr. Brock. We've asked for this already and been turned down, so we're asking again, and we'll have a Minister of Justice here who can answer the question yet again. I don't think his answer and the reply that we get is going to be any different. So so that's the only question I raise around those legal opinions. I think it's something that we may want to ask ourselves whether or not we're going through another exercise for not. And then the only other point I wanted to make is with respect to the reference to other witnesses in the motion put forward by my colleagues from the Conservatives it's for me is so far open. Like Senator Harder, I feel like without knowing what that looks like, it seems like it's an endless exercise to me. So I want to reiterate, I think what I'm hearing from everybody around the table is that we want to figure out how we take all the information and all the work we've done over the 26 meetings and all of the material we have that we can work with and continue working on a report and recommendations in a way that introduces the new information around Justice Mosley's report and try to figure out how best to come to conclusions that are valuable for Canadians. Thank you.
Merci, Sénatrice Bonny.
Thank you, Senator Boniface. And now it's my turn. Madam Senator, could you please chair the meeting while I ask my questions? I will let you chair in case you need to, call me to order. I will not repeat everything that's been said. But listen, we've had previous discussions on the production of documents. And I don't see an issue. I mean, I agree with everyone that we haven't seen the an intention on anyone's part to offer a translation of all those documents. I've observed that, and I agree with Mr. Green that I'm not going, to be able to study, I don't know how many thousands of pages before starting to draft an opinion. If I have all those documents in French, I could choose which appear most relevant and which appear less relevant. But if my, selection is poor and I leave aside a document, I'll be the only one responsible and I can live with it. But I'm being told, tell us what document you want to see. But that exercise we did. You'll recall not so long ago, we said, seeing as we can't get, I don't know how many millions of pages, let's ask for an index. And once we get the index, we'll be able to choose. Although that, of course, is not perfect, but we could have at least have been able to see, well, that's not so interesting, that is interesting, and do that exercise. But we don't have the index either. I think it was, 16 million for the index, 300 million for the translation of the documents. Actually, I'd like to hear from a representative of the Privy Council to see how they made that assessment. It appears a huge amount. So I wonder, well, it's impossible to get the documents when in principle. We should be able to work in either English or French. And I think Senator Carignan is right when he says it's not just a problem for the Francophones. Anglophones are also deprived because there was testimony in French and Anglophones did not see it. Now, would that have contributed to changing your opinion? We don't know, and you'll never know because you'll never read it. And that appears to me to be a problem that will affect the quality of our report because we haven't been able to perceive the entirety of the evidence. And I've said it already a few times. We've got to decide whether we want a bilingual parliament or not. We can't say we want it bilingual only when it doesn't cost too much. And if it costs too much to be bilingual, well, we'll have to then determine as of what amount it becomes too expensive to be bilingual. So I don't know. We can't, do without this. In a way, it's fundamental. But I think and with all due respect, Ms. Romanado, you have a very good motion, and I congratulate you because for a newcomer to arrive, you seem to have understood what's at issue, and it's the issue of translation and the issue of Mr. Mosley's decision. With all due respect, I also think that it's, cutting the corners too much. As long as I don't know what the documents are at the Rouleau Commission, and once I should be entitled to, given the motion that was adopted, a year and a half ago? I can't, go about this in halfway. I can't select documents. I mean, I think Mr. Green, and with all due respect, I might be saying, he said, you can choose those documents you deem important. That's all very well. But if I don't know what documents are available, how can I decide, which ones are important? It's a bit like you tell a child, tell me, tell me what candy you want when he hasn't seen the kind of candies there are, and he doesn't choose the candy because he didn't know it was in the platter. In any event, I would need to hear from the Privy Council. I want them to explain, first and foremost, the story of hundreds of millions of dollars to translate these documents. I expect they'll give us convincing arguments. I look forward to hearing them. That's a first step. Then explore with the Privy Council what can be done so that it can at least get an index or a list of documents or a minimum amount of material with which to work to be able to identify the documents for which we need translation. I would bet probably that the report we draft will have to mention that we did not have access to all the documents. That we might not have no other choice, but we can't be lazy at this stage. We have to be rigorous, try to get as much information as possible to draft a report that is most rigorous possible. And that's it for me, Madam Chair, for now. Ms. Romanado, I'll give you the floor. You're next on the list. Go ahead.
Merci beaucoup, Monsieur le Président. Given the fact that I think the last hour and a half we've been discussing and referencing my motion, I actually think it would be a good time to actually discuss the motion. And so I move that the committee proceed to another order of business, that being my motion.
Sur ça?
It's dilatory.
Oui, mais un point d'ordre, c'est ça, Monsieur?
Is that a point of order, Mr. Green?
Discussion, which was that we would take some time during our call for votes just to see if we can get some kind of common ground before proceeding to your order of business, because in doing that, we may be presupposing an opportunity to find common ground. And so I would respectfully suggest that happen after the votes rather than before. We're heading to votes now, right?
Madame Romanado, si j'ai bien compris.
Ms. Romanado, I've understood what you suggest is that we vote on your motion. No, I proposed a dilatory motion to change the motion before us, to stop discussing Mr. Brock's motion, but to discuss mine, to maybe find a formal way to go, because I haven't yet been able to speak to the motion. Well, then I'll ask for a little break. But I thought we have been discussing both motions in parallel from the beginning. Well, let's suspend 2 seconds, and I just want to check with our clerk.
That's funny. Let's stop discussing Brock's motion. Let's discuss mine. For anyone that's new to the channel, please like and subscribe. And if you can, give a donation to the channel. It does help the channel quite a bit. You know, I'm really curious as to how much all these committees cost, because they do studies upon studies upon studies. Like, literally. They'll have a study about another study. And it goes on forever. I wonder how much it costs Canadians for all these committees. Ceases. Yeah, a lot of these committees are a waste of taxpayers' money. Huge, huge waste. But it's a way. Some of the committees are a way to crush a topic so that, you know, it never makes it through the House. So they send it to committee, and then they spend like a year or something on it, and then they crush it. You know. Perfect time for a commercial break. What happens? Then you have to speak Arabic. It'll be in like 40 different languages. The way this country's going, I would not be surprised. Yeah, so tomorrow when you guys come back onto YouTube, check out my new channel. You might not be able to find it. I'm not sure if you can find it right now. There's no videos on it yet, but it should be available tomorrow. The house is still currently active, Jonathan, so there's no time for available for tomorrow's proceedings. What is tomorrow? Wednesday? I think Wednesdays are 2:00. I write this stuff down, but my desk is a mess. Yeah, tomorrow's 2:00, Thursday's 10 a.m., Friday's 10 a.m. No, I'm going to continue with this channel for my live streams, but all of my clips and my videos that I make out of my live streams will go directly to the new channel. So this channel will be specifically for live streams until whenever. Yeah, I mentioned about a new channel. It's UD Conservative. Capital U, capital D, capital C Conservative. Have a great night, Kenzie. Yeah, if you can find the channel, then go ahead and subscribe. But I don't know if the channel's available until I at least have one video on it. I'm not really sure. But it's at UD Conservative. I'll write it back in the chat again, my handle. Have a good night, Sonny. Thanks for joining us. What channel? It's UD Conservative. It should have the exact same emblem on the channel as I have in the corner of the feed right now that says UD Conservative Canada. Yeah, it may not come up because there's not a single video on it yet, so it might not actually show up as a channel. So that's why I say you might have to wait until tomorrow. Yeah, I'm getting wiped. I've literally sat in this chair streaming since when did I start streaming? 10 o'clock this morning? Like, I've left this chair like twice, 2 or 3 times. It's ridiculous. I'm getting fat doing this. I need like an exercise machine beside these computers because there's so much to. I gotta watch everything. Yeah, hopefully with this new channel, YouTube doesn't try to squash me. Okay, so you can find the channel. You have to keep the @ symbol. When you search, keep the @ symbol there and put UD Conservative all as in one word, and it will bring you to the channel. Just copy and paste what I put. Just copy it off the chat. Yeah, give your balls a tug. You got to keep the at in front of the channel because there's no videos, so it's not going to recommend the channel. Yeah. Yeah, easy. So you just keep the at there, right? And put the UD conservative together right beside it, and you'll get it. Just copy the way I put it on there. Just copy and paste it or something. I'm hoping to get a video up tonight, but this is running pretty late. And sometimes it takes like a half an hour just to cut, like a 3-hour video. You did that and you couldn't find it? It should be like it's like a blue emblem. Weird. Jonathan, you found it? Perfect. Thanks for subscribing. There you go. Give your balls a tug. You found it. I can't even. Every time I say your name, and then whatever follows after it. This is ridiculous. Give your balls a tug. You found it. Yeah, really, I need to go. If anything, I need to go run on a treadmill for a little bit. Like, I've sat here all day. It's ridiculous. Like, if I was some of the other guys where I just make a video, and that was it. Like, I'd make 1 or 2 videos a day. I'd be fine. But because I do a lot of streaming, I literally have to sit here all freaking day. It's like having an office job. It's brutal. Yeah, I'll probably wait till tomorrow before I put up the videos anyway, just because I know that tomorrow it doesn't start until 2 o'clock, I think it was, so I'll have lots of time during the day to actually do that prior to getting ready for the live stream tomorrow. I've seen these committees do this before where they try to run out the timer, they come back for 10 minutes and they're like, meeting's adjourned. Perfect. Now you can subscribe. Oh, I thought we had something there for a second. I wish I didn't get like dinged for copyright stuff. I'd just play anything right now while we were waiting. Yeah, my new channel's got a new design, new logo, new feel. It actually looks pretty good. The actual House of Commons right now is actually voting, but they should be done. I don't even know why they're still going. No, well, some things are public domain, like the music that is playing right now that you guys can't hear, that's playing from the feed, is public domain. But the big but is that it's gonna get flagged as it not being public domain, which means they'll demonetize my video for a month. I'll have to fight it for a month. I had like 4 videos where they sung "Oh Canada," and it got flagged as copyright material for "Keep on Rockin' in the Free World." That's what they flagged it as, and it took me a month to have that channel so I could monetize it. So I lost a month's worth of income from it. Right now, I'm not collecting anything. I'm not getting paid for anything that I'm doing now because the channel's lost all of its monetary value, but yeah, it's crazy. Trust me, YouTube, well, Google, sorry, because Google owns YouTube, they're super strict. Very strict. If you're going to have music play, it can only be for like, I don't know, maybe 10 seconds or less. And then you have to keep muting it. So when, like on Thursdays, where they sing "Oh Canada," I have to mute it, unmute it, mute it, unmute it, so I don't get dinged for copyright. Because it'll get dinged as "Keep on Rockin' in the Free World." I don't know. I've disputed "Keep on Rocking in the Free World" twice to them singing "Oh Canada" in the House of Commons. Just the algorithm. The algorithm's horrible. I was looking at my stats and my videos are literally being like super hardcore suppressed. So YouTube's like sending out to like 2% or something like that is what my YouTube suggestions are. Oh, come on. Now I think they're just like wasting time. This committee is gonna be a crappy committee because it's mostly liberal and it has NDP. There's literally 2 conservatives on this committee. That's it. The rest are all NDP, liberal, and like 1 LeBlanc. Yeah, I'm Eastern Canada, so my time is the exact same time as the House of Commons. I'm like 3 hours away from Ottawa. Yeah, I think that's a lot of the problem too, is there's all this censorship and nobody realizes how much they are censoring things. Like, and the Conservative Party called it out a long time ago, but half the people didn't believe them. Like when it came to this news and the Heritage Committee trying to squash everything, so they were promoting more French and less English and all that. When they were doing that stuff, they were censoring a lot of crap. Oh, I wish I was 3 days away from Ottawa. That'd be sweet. Wish I was 3 days away from Canada. What did you suggest to me? Hey, James Lucas, you said that you suggested something to me months ago. Or are you talking to somebody else? Right? Nobody can. You know what's crazy though is that YouTube's replacing TV. So like cable and all that stuff's eventually going to go out, and YouTube's going to be the new form of television. That's just the way it's going, and they're set to replace cable, and they will. Man, these guys are taking forever. Yeah, it'll all be streaming platform. Does anyone have Amazon Prime? Because Amazon, which pissed me off, just switched it so that they now have ads in their content. It's like so I pay once a year, and I've already paid, and I'm sitting there watching. Then all of a sudden I get an ad. I'm like, what the shit? And then after the show I was watching, I got another ad. I'm like, you gotta be kidding. And then I apparently I got an email or something to indicate that I was gonna get ads. They said something in September, I guess. I don't know. I was like, somebody that's already paid a month in advance, you think you would warn, or a year in advance, you think you'd warn them, or at least wait until their subscription's up and then tell them when they renew that, okay, it's going to be with, or, you know. Netflix didn't screw their customers like that. Yeah, they had a thing pop up and said, do I want to pay more money? I can pay more money and not have ads. I was like, I just paid you $100 for the freaking streaming service. What are you talking about? Why would I pay you more? What, am I rich? I don't think so. I got a YouTube channel that doesn't pay me. I don't get nothing. You do your thing too. I find that's always the best way to go. Then you're not, because with all these streaming services, it's like you got things coming out of your bank account, you know, all different times. It's brutal. Too hard to keep track of. At one time, I had like 12 different things coming out of my account at different times of the month. I was like, it makes it really hard to manage your money, especially when you're like me and all you do is spend money. Right? How else are they going to provide mis and disinformation? You're not wrong. Yeah, it's crazy. You know, I actually got rid of Netflix at the beginning of last year. And I was like, Netflix isn't coming out with crap. And they charge way too much. Like Netflix wants $20 a month, and then they don't really give you all that much new stuff. Or they'll come out with a season or two and then cancel it. So I was like, screw it. I'm going to go back. I'll get cable. I got the biggest internet cable package I can get. I complained and complained and complained about it. So I got it for like dirt cheap. Yeah, I got like 100 and some odd channels or 200 channels. I don't know. But half of the channels they have the same thing on. You have 5 or 6 channels, they'll all be the same thing. Then 5 or 6 more channels, it'll all be the same thing. It's like, holy crap, these guys not show different stuff. Yeah, I got a VPN on my my TVs, my cell phone, and my computer. I just never use them. I don't know why. Yeah, exactly. Everything's a rip. Well, it's like these streaming companies or whatever. They gotta get in on the monopoly in Canada, so they're charging people extra. And some people don't. I know some people that just watch DVDs all the time. Just watch Blu-rays. I personally can't do that. I can't. Half the time I can't even watch a movie until I go to bed anyway. I got ADHD, man. I gotta keep my mind occupied. It's funny, I've been off work for like, I think, almost 2 years now. Since I hurt myself 2 years ago. And, God, I probably gained like 80 pounds. It's ridiculous. I'd do anything to go back to work. It's always for the best. You know, when I was young, I never watched TV or anything. Man, I was gone all the time, 24/7. 24/7, I was gone. I was always outside. Yeah, see, that's the thing. Like, I have ADHD and I do have a little bit of OCD. My wife hates it. Yeah, I think the conservatives are at like 43%. What are the liberals at? 24% or something like that? Or 24 points? I don't know what. I'll have to look at it again. Well, 338 Canada are projecting conservatives at 203 seats. Yeah, that's crazy. And liberals at 70. Well, looks like the Block's doing better than the NDP. That's weird. There's no way that's right. Yeah, that's all Trudeau's in there for. Is he's just in there to line the pockets of his buddies and make himself richer. That guy went from $10 million to over 400 and some odd million dollars. How is that even possible? What I don't understand is if he got a bunch of profit from Pfizer, like from like shares in Pfizer, that's some sketchy shit, man. I'd be like, well, the only reason why that guy chose everyone to have those shots is because of he was going to make millions off it. It's like insider trading. Yeah, this country's nuts. This country is nuts. I think we let liberals, well, not even liberal, I wouldn't even call them liberals, the far left, I think we let them triumph for too long. The weak people have been leading the country for far too long. That's far wrong. The far wrong? What does that mean? The thing is, we'll never see it. That's the problem. We'll never see anything. You know, it'll go into an election at some point, and then we'll have an election, and all the stuff will just disappear. We'll never hear about it again. And then, you know, Pierre will probably be like, well, we can't do this, we can't do that. And that'll be because, you know, every politician is corrupt, and they don't want people, you know, breathing down their neck. Yeah, the far left is far wrong. I definitely oppose the far left. They've destroyed the whole world has been screwed because of them. Yeah, those are good numbers. The problem is that they got those numbers now. Unless we're going to go into an election really soon, those numbers won't stay. What they're doing is they're like, the worst thing is that they have high numbers, and it's going to be impossible to keep them up that high. Because over time, the liberals are just going to keep, you know, they're going to use certain things that the conservatives do as fuel to throw out to the public all the time. So every little screw up the Conservatives do, the Liberals are going to be right there to put it out in your face so everyone in the world knows. Yeah, it's, Conservatives, Liberal, NDP, some are a little more deranged, but in the end, they all end up screwing us. I'm hoping. I like, this country has been screwed, man. Somebody needs to go to jail, and preferably not me. What's happened to this country is just unreal. Yeah, they need to put safeguards in so that, if a prime minister starts acting the way that Trudeau has, then we can force them out. What happened to people having the power? The power is with the people. That just blown out the window. Like, Trudeau doesn't listen to his constituents, neither do any of the other Liberals. I guarantee they get hate mail daily. Guarantee. Daily, they probably get hate mail. Like, Trudeau's got to walk around with a bulletproof vest, so he's getting hate mail. That's like Harper in his last term. Every time he spoke, he had to speak behind bulletproof glass. So, there's crazy people out there that do crazy things. Yeah, they should abolish that so you can never do a coalition again. Because to me, it undermines Canadian democracy when you can just, you vote for someone to have a minority government and they can just do whatever they want. They just form a coalition, or at least a supply agreement. And they don't like to say it's a coalition, but a supply agreement that allows them to pass any legislation they want as if they were a majority government. Now that's wrong. So right now, that's what's happened, is that Trudeau and the NDP are acting as one majority government. It's bullshit. No. Nope. And I hope that none ever do. But I do hope one goes to jail. Yeah, I think these guys are just running out the clock. What's funny is that Jagmeet Singh or whatever, he is the one politician you see the least. I thought Trudeau was bad, but no, Jagmeet, he's the worst. Oh my god, did you guys see the video of Jagmeet? Where was he, in Toronto or something like that? Anyway, he's riding it like this pimped out bike down the sidewalk, and people were calling him out because it's illegal to ride a bike down the sidewalk. It was hilarious. He looked like such a stooge. Well, normally laws pass through legislation, so that's the House of Commons. Some, I guess, would go through the Senate. The unelected Senate. I don't know why we have one. If they wanted to, what we need to do as a democracy is make a triple E Senate. So it's an elected Senate. You elect them, the officials, and they share the power with the government. So that way that not, if by chance there is a coalition or anything like that, the Senate can take power and stop them from passing legislation and other bull crap. They need the cooperation of the Senate. That's what Canada needs. It's a triple E Senate. I know these guys are probably getting paid in there for just shooting the shit. What do they get paid an hour, you know? $5,000? I thought he said he did. I was watching, like while I was streaming here, because I do a bunch of other things at the same time. I was watching the news, and he had like a little conference thing or whatever, and he said, you know, if it comes to it and he doesn't, as of March 1st, then we will go into voting. He needs to back away because he's going to destroy his party. That's the thing, is the NDP are going to get their reputation's on, well, reputation's already gone, but it's definitely on the line. Right? Oh man, this country is falling apart. I wonder when they're going to bring up the petition. They still have to, bring up that petition. What is it? 4701 or something? Yeah, E4701. They still have to pull that petition out because they haven't made a call on it yet. They just put it on record is all they did. The Senate can only refuse legislation if it's put to the Senate. But here's the thing, is that a lot of the members that are independent on the Senate are actual liberals. They're appointed by the Liberal Party. What they need to do is wipe out that Senate altogether because they're not elected officials. So they shouldn't have any say over anything. And then elected Senate members be put in there. The only reason why he's barely not surviving his leadership review is because he's not very involved with politics whatsoever. Not like the other opposition, like Pierre and Trudeau. They're both way more involved in politics than Jack Mead is. He just sits in the background and then jumps in every once in a while. But he's not as involved. Plus, I think half of his party is divided on whether or not they should still hold up the Liberal Party because it's going to hurt them in the end. And a lot of the members on the NDP are going to lose their seats because Jack Mead has a supply agreement with the Liberals. Well, he's an idiot. He's going to be reamed out for the rest of his life. That's the thing, is that every time somebody sees him, they're going to have something nasty to say to him. He's a traitor. The thing is that Jagmeet Singh has his hands clean. The Liberal Party has their hands dirty as all hell. But the NDP don't. Their hands are clean. They have no involvement with the scandals of the Liberal Party, except for kiboshing committees that are looking into the Liberals. But, you know, they just wipe that away. Those of you still sitting in here, listen to me ramble about nonsense, please hit the like button, subscribe, help the channel. The channel's not doing too good. It was until YouTube decided that they didn't want me having a channel anymore. Yeah, well, I'm sure there was liberals in the Liberal Party too that were like, wow, why is he pulling out the Emergencies Act? You know, believe it or not, there are probably really good liberals in that party. There are some old school liberals in there, but Trudeau likes to get rid of caucus members and liberal members that he has, cabinet members, the moment they go against him. He throws them away. So I think that's why they're all like, yeah, we're for it, don't worry, yeah, we'll vote with Trudeau. Why they defend the guy so much, because they know they'll be out the door. Right, Mike? I feel the exact same way. I feel like they are working up so that we never have an election again. Like, why would the United States government do all the scandalous crap that he has been doing, and Trudeau do all the scandalous crap they have been doing, knowing that there is a chance that if they get out of politics, like when they're done, they're going to go to jail? Why would they do that if they knew that there's that possibility? Unless they just plan on staying where they are. You know, that's the thing. Who knows? Maybe that's me just speculating, but of course they did. Well, there was Trump ballots thrown in ditches and everything. The real president of the United States should have been Trump. You don't have that many people in your country. Like, the amount of people that rally for Trump is like insane. So you know the guy is supposed to be their president. Not the candidate that's currently president that only has like 40 people show up to a rally. Yeah, well, I've had a few, you know, like Clyde Say Something. He used he used one of my videos on his channel. Or is Clyde Do Something or something? I don't know. But still, it's just like it's hard to collaborate with other channels because some of them are competitors. So I'd have to collaborate with like the pleb or something because he's news. Oh, I guarantee Charlie Angus is lost. He'll be done. Especially after the crap that he's pulled. Like this guy literally is a commie. There's no way he's not. He wants to make it illegal so you can go to jail for talking well. Okay? He puts in his thing for talking well about oil and gas. So just speaking well about it, you could go to jail. That's what he wants to pass. He wants to pass that into legislation. That is ridiculous. That's worse than cigarettes because people can talk about cigarettes and not go to jail. I think if you see another sabotage in Trump's presidency, you're going to watch a civil war. That country right now, I swear to God, is probably already at the brink of civil war. I can't stand Charlie either. He's quite the socialist. All he is about big government, little people, hard laws. Hmm. Yeah, I don't know why these guys are still whatever the hell they're doing here. Yeah, there's some people that just should not be in the parties. Like, they're too controversial. Like Randy in the Liberal Party, like Bozeman or whatever. Is seriously, that guy should not be in the Liberal Party. He is super controversial, and he is playing offense against one of the biggest demographics in this country, and the parents. Don't mess with parents, man. Don't mess with parents and their kids. That's how you start a war. Because parents will die for their children. You really think you want to stand in between a parent and their child? You're going to come out in a body bag. Yeah, I don't know. I know he's gay. Randy is gay. That's why he's all for trans rights and all this stuff. But he's like one of those really woke gay guys. He's not a normal gay person. Gilbo is a criminal. Like, I have met so many gay people, and a lot of them are totally against all that woke crap and trans stuff and yeah, it's just crazy. Yeah. Oh yeah, it's here, let me type it in. You gotta like copy and paste it. But that's the new channel, so I will be putting clips and my videos on there. I probably won't do live streams on there. I'll probably just stick with this for live streams. But eventually, we'll see what happens. If this channel doesn't improve in a while, then I will end up shutting it down at some point and just continuing on with the other channel, because it's not profitable to operate this channel. I made 50 cents last week. Like, it's not worth the work, you know? Yeah, it's brutal. Like, I don't know what these guys are doing. Are they coming back or what? They're supposed to come back and at least say whether or not they adjourn. Well, I think I'm going to cut it off here, because they're obviously, if they come back, they're only going to adjourn, because the meeting was only until 5 o'clock. So I might as well cut off the channel now, and then whatever, it really doesn't matter, because the only thing I'll be missing out on is them adjourning. So I'll tell everybody good night. I should upload a couple videos onto my YouTube, my new YouTube channel. Tell all your friends tomorrow, and we'll try to get that channel up, get it monetized, and go from there. Have a wonderful night, guys.